It is. Senator Wright.
I move business of the Senate notices of motion numbers 1 and 2 standing in my name for today and indicate that I intend to address my remarks to both motions. As the instigator of these disallowance motions, I rise to highlight exactly what they will disallow, and I urge the Senate to disallow these provisions. In so doing, the Senate will send a clear message that we are looking out for vulnerable people in Australia. The Australian Greens will act to protect those who are doing it the toughest in our society whenever we can. Last year's MYEFO, Mid-Year Economic and Fiscal Outlook, directed the Australian Financial Security Authority to recover its own costs by introducing a new $120 fee for people who apply for a debtor's petition. So what is a debtor's petition? Well, it's a form of voluntary bankruptcy. A person would file for a debtor's petition when their debts are insurmountable, if all other options have been exhausted, and when they have finally, often after a long protracted period of decision-making and steps, have decided to take control of their own finances by filing for this form of voluntary bankruptcy. In coming to the decision today to disallow these regulations, I've been closely consulting with consumer advocates and financial counsellors, and in particular representatives of Financial Counselling Australia and the Consumer Action Law Centre, who brought the consequences of this fee to my attention. Many of us in this place will not have personally experienced the stress and worry that others are facing as they struggle to get on top of debts that have become stifling. I have no doubt that some of us actually will, but I would think that probably less in this place than in other areas of Australia. These debts will be often impossible to deal with and constantly, like a living nightmare, there day by day. Often people just have no way of sensing how they can get out of the financial nightmare that they're in. Some Australians are in fact in the midst of that nightmare right now as we sit here in this place. Just last week, I met with some financial counsellors in South Australia who told me about the experiences of a couple of their clients. One of them told me about a man who had developed a serious physical illness, a debilitating illness. He, along with his wife, had been running a small business and had been struggling to continue with the business and pay his mounting debts. He was initially very unwilling to consider bankruptcy because he considered his debts his moral responsibility to repay. But the situation was becoming increasingly hopeless. There was no end in sight in terms of recovery from his illness and the ability to resurrect his business. And he finally came to a decision to petition for bankruptcy. But indeed, this fee that came into effect on the 1st of April was one more impediment after a long series of steps and processes that he'd undertaken in coming to that decision. And again, the situation seemed to him hopeless. What these financial counsellors were at pains to convey to me, and have been all along, is that people do not undertake voluntary bankruptcy lightly. There is still a strong sense of shame and stigma in Australian society for people who have had to publicly acknowledge that they have financial circumstances that have become out of their control. So it usually does occur after a long process of consideration and a series of steps. But then with that final decision, which they always make on a personal basis, the counsellors tell them the options, but always it's the client's personal decision. But with that final decision, there often then comes a sense of relief and starting to have a reassertion of control over their lives, that there's a light at the end of the tunnel. However, what I have been hearing consistently from these representatives of vulnerable and marginalised people in Australia largely is that this final fee, this fee of $120, was just one more impediment and often, in fact, impossible. Now, $120 for some of us people on our incomes may seem a meal out somewhere, perhaps, for a couple of people. But in fact, of course, there are many, many people in Australia, many people who are struggling at the moment on low incomes. And I'm not even talking about fixed incomes on pensions, but people on low average incomes who would find $120 in the budget just impossible. And of course, people who are contemplating bankruptcy are at the absolute other end of the spectrum where they have no sense of hope of being able to control their finances. So where do they find this money? They find it. Can they put it on a credit card? Well, probably their credit card is going to be one of the components of the debts that they're not being able to manage. And even if they were and still had some credit limit or were able to do that, arguably that would be fraudulent because they would have a knowledge at the time they put the fee on the credit card that they would have no means of repaying that. Payday lenders, and we know about the risks of going to payday lenders and the exorbitant interest rates that they pay. Or do they go to an agency, an NGO somewhere who can support them to find this fee? And of course, that's cost-shifting at its worst, but increasingly that's just not going to be possible. So financial counsellors have been telling me that this fee will mean that those who truly need to go bankrupt may be, ironically, the very people who cannot afford it. Since the fee was introduced on the 1st of April, just after the Senate rose from the autumn sittings, I've been told it has already made it harder and more complicated for vulnerable people to decide to file a debtor's petition. It's already acted as a disincentive. And in fact, I questioned the authority in Senate estimates in May about this, and the authority's own figures confirm this. Now, it's difficult to draw conclusions after a short period of time, of course, and there are seasonal factors, and from year to year numbers go up and down, but certainly the number of people filing for a debtor's petition had decreased since the fee was introduced. The alternative, if a person cannot take this step to resolve their nightmare situation and where debts are just insurmountable, is to live with the anxiety that someone else may well then force your bankruptcy at any time. Any of your creditors can do that, but of course that means that it's out of your control and you don't know when the blow is coming. Now, I just want to, I suppose, deal with a few furphies that float around. It's easy to accept we know that there's a bit of a common sort of prejudice, I suppose, that maybe bankrupts are high-flying entrepreneurs who had one luxury vehicle too many. Maybe people like the Christopher Skazers of this world might come to mind. But in fact, that's just not an accurate representation of the sorts of people who are needing to make this difficult decision. AFSA's own figures show that this is a false image. They show that unemployment is by far the biggest cause of personal bankruptcy in Australia, and that most people earned less than $30,000 in the year before they ultimately became bankrupt. Forcing people to live with debt that they can't repay is not only unfair, it's bad for the business sector and the economy, and that's why the business sector, especially those who are common creditors, is on the record saying that the fee indeed should not be introduced. Because continued accessibility to an orderly, methodical means of resolving an ongoing situation like this and accessibility to bankruptcy not only supports debtors but also creditors and the entire financial system. They know that a very real consequence of this filing fee is a reduction in the number of debtors' petitions filed. And the Australian Greens will stand with people on low incomes, consumer advocates and the business sector in saying that this fee is not acceptable. So that's one of the reasons that we're disallowing these instruments as an unfair and rather unsophisticated way to recover costs. The introduction of the debtor's petition fee hits disadvantaged people the hardest, quite obviously. Often they will have no other means to support themselves. And in the wake of a federal budget where we know that it is actually going to have increased adverse effects, it's a cruel budget on people who are already struggling, people who are unemployed, older people, single parents, people who are already doing it tough. We know that these people, frankly, are already in trouble. And cuts to services, cuts to benefits, the proposal that young people under 30 who aren't earning or learning will then be without income support for 6 months, all these conditions are right to see an increase in the number of people who would be facing this incredibly difficult decision to file for bankruptcy. The Australian Financial Security Authority, which is introducing this fee at the government's direction, has published figures which show the profile of those who this fee would affect. Unemployment or loss of income has consistently been nominated as the most frequent cause of insolvency for non-business-related bankruptcies since 2003. The majority of bankrupts who owed less than $5,000 in 2011 were not employed at the time of bankruptcy and had low-level utility debt. As the Australian Greens spokesperson for legal affairs, I have fought for people's access to justice. And despite successive governments' obsession with full cost recovery increasingly, the Greens believe that institutions like courts, tribunals and bankruptcy in Australia provide an essential service in ensuring that people have avenues to pursue their legal rights. I think the assumption that essential services such as these should earn back their own costs needs to be questioned. When the Labor government raised federal court fees, Senator Brandis, at the time, now the Attorney-General, he was the shadow at the time, called it another disguised Labor tax. But the messaging, of course, has changed now that he's the Attorney-General and looking at the same thing in relation to courts and so on. Financial counsellors emphasise that no person makes the decision to go bankrupt lightly. It's considered as a last option, but an appropriate one in some cases. I do want to just indicate that as a result of the moving of a notice to disallow, so the intention of the Greens to disallow these regulations, it has been a clear message sent that the Australian Greens are willing to act to heed the policy advice of those people who are currently working to assist some of the most vulnerable people in Australia. As a result, I have had the opportunity to make the case to the Attorney-General's Department and to representatives of the Attorney-General himself. And as a result, I do want to indicate there have been a series of productive meetings where representatives of Financial Counselling Australia and the Consumer Action Law Centre have been able to strongly advocate against the introduction of this new fee and painted a picture of the detrimental effects on their clients. They've been able to put to the government that instead of hitting the most financially vulnerable people in Australia to close the debt recovery loop, the government could look at other options to nuance, for instance, the realisations charge, which applies to all administrations under the Bankruptcy Act. I must say I do find it somewhat ironic that these are highly respected, highly expert people in the area of dealing with consumer credit issues with vulnerable people in Australia by virtue of being the Financial Counsellors Association and the Consumer Action Law Centre, which is a community legal centre. And they have indeed, I suppose you would argue, been engaging in advocacy, in taking their combined experience of the effects of law change on their clients and making a strong case about a better avenue to take, a better way of changing the law so that their clients are not disproportionately affected. So, ironically, given the new mantra from the Attorney-General that funding for these sorts of organisations, particularly community legal centres, is not ideally used for advocacy and shouldn't be used for advocacy and should be used for frontline services, would mean that perhaps in the future this advocacy may not be so possible, or indeed the representatives of those organisations may have to be doing it on their own time, in their own hours, which would mean that perhaps the meetings would have had to have occurred outside business hours. But in any case, there was an opportunity for these representatives to be able to meet with representatives of the Attorney-General's Department and the Attorney-General and make the case about why this particular change to impose a $120 fee that had not been there before, against the evidence in other countries that indeed that the fee then becomes shifted and creditors end up bearing the cost, or else it shifts to government agencies. They were able to make that case, and I do have an understanding that in fact there may be a proposal, there may be action coming forward on the part of the government to indeed waive that fee entirely and to find some other means of cost recovery. Perhaps by increasing the asset realisation charge with a review to see how that's going ahead. If that's the case, I would certainly welcome that. That would certainly be something that would ameliorate the worst aspects of this fee, as it has been indicated to me and conveyed to me and to the Attorney-General's representatives. And in that case, it may be that there won't be a need to look at disallowing a fee further in the future. So we'll wait and see what comes out of that. But if that's the case, then I would like to think that this has been a good example of a process whereby good policy can be pursued on the basis of information and evidence coming forward. So, just to finish, I would be saying that the Australian Greens do urge the government to nuance its cost recovery measures with AFSA in a way that provides real relief and good policy for those people who are making the most difficult decision to file for a debtor's petition, and which indeed provides a genuine benefit to the Australian community, including the business and finance sector. So I would be moving that the Senate supports this motion. Thank you.